defense doctor is on the stand now testifying different than what he testified to in deposition. Can you bring up these inconsistencies to the jury? Hello, I'm Marcus Boston, and I'm a medical malpractice attorney practicing law here in the state of Maryland, and I would like to talk with you today about inconsistencies from, say, a deposition to trial. Now, you're sitting up in trial, and your defendant, the defense doctor, your doctor is sitting up on the stand testifying as to what he or she did in your case. And you hear the questions come up dealing with a differential diagnosis. And now in court, the doctor is saying that he did a differential diagnosis and he did X, Y, and Z to rule out certain types of medical conditions. But you know that during the deposition, the doctor stated that differential diagnoses are nothing but tools that are used in medical school and that they're not used in real life practice, and that the doctor did not use one in your particular case. Now, hearing these inconsistencies, you lean over to your attorney and you ask your attorney, can we bring this up to the jury? Can we show these inconsistent statements? And the short answer is that yes, you can, as long as certain conditions are met in these particular types of situations. Now, these particular types of issues with inconsistent statements like this are called hearsay exceptions, and they can be used as long as the person who's testifying, or let's say at the deposition, they're now here at trial and they are subject to cross-examination. As long as the statement, the inconsistent statement, was made during the deposition, and at the time during the deposition, the person giving the statement was under oath, subject to the penalties of perjury, had an opportunity to review the deposition and to sign off on the deposition, or if there was a court reporter, a stenographer was there, or some type of recording device which was recording the deponent's testimony, then if all of those conditions are met, then yes, you can show the inconsistencies to the jury. So you can use the statements that were made during the deposition and show the difference between the statements made there versus what the doctor is now testifying to at trial. Now, I realize you probably have way more questions about this, or you are probably wondering just, are you the victim of medical malpractice? And if you are, should you talk to someone? Well, if you have these questions and concerns and your matter happened in Maryland, this is what I invite you to do. Go ahead and pick up the phone and give us a call. I can be reached at 301-850-4832, or if you prefer, you can send me an email to medicalinjury@bostonlawllc.com. We answer Maryland medical malpractice questions like yours all the time, and I'll be glad to listen to your story. Well, guys, that's going to be it for today's quick educational video. Again, I'm Marcus Boston, and I'm one of the medical malpractice attorneys here at Boston Law Group, LLC, and we will see you next time. Guys, take care and enjoy the rest of your weekend.